We have important news out of the United States Supreme Court that may not be obviously touching fingers with the Second Amendment, but it's really important for our rights. Specifically, the United States versus Fischer case arising out of charges against defendants involved with the January 6th protest. A big decision by the U.S. Supreme Court to hear a case involving a federal statute, 18 U.S.C. 1512C, and what it means. This is a big deal for our Second Amendment rights. Why? Because there was no circuit split, and yet the Supreme Court just agreed to hear this case because of its importance. That's very important for our rights associated with quote-unquote assault weapon bans. You'll see why when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a two-time nominee in two separate categories for a 2024 Gundy Award for a top male influencer in the Second Amendment space and for our top voices of the Second Amendment. I am proud and honored to have been nominated in both categories. All right, folks, so this is not obviously connected to the Second Amendment, but it actually is, and it's actually very good news for us. Specifically this week, the United States Supreme Court just agreed to hear a case, having granted cert, in a case called United States versus Fischer, which involves charges brought by the Department of Justice arising from the federal criminal statute 18 U.S.C. 1512C, which specifically provides that one may not corruptly engage in some sort of interference or obstruction of an official proceeding or official governmental process. We'll get to the details of that in just a minute. But the reason why this is important to the Second Amendment, and then we can talk a little bit about the case just because it's interesting. The reason why this is extremely important to our Second Amendment rights and a good sign is this. One of my fears as a supporter of the Second Amendment is that when it comes to quote-unquote assault weapon bans, which as you know are political propaganda terms for bans on semi-automatic rifles and magazines that hold more than 10 rounds. When you look at those laws are being enacted in the same handful of anti-gun states that are largely controlled entirely by the Democrats, whether it be the governor's office plus the legislature and so on. So you're looking at places like New York, New Jersey, California, Oregon, Washington State, which despite having large numbers of actual Americans there, red state Americans, heritage Americans, whatever you want to call Americans who support the right to keep and bear arms and our Constitution, these states are controlled in terms of the government by Democrats, blue state Democrats. And what's happened is because the anti-gun movement has been doing so poorly, they've devoted a whole lot of resources to these blue states because that's the only place where they can effectuate change, because they're not going to accomplish much anti-gun laws in a lot of the red states as permitless carry remains on the march and people recognize the dangers associated with being unarmed in a world that's becoming more and more unsafe and our government refuses and or fails to protect us. So the reason why I bring this up is because while the blue states are going crazy with things like quote-unquote assault weapon bans, the red states are not. Now, the reason why this is important is because when the U.S. Supreme Court decides to take on a case, one of the things they often look for before they accept a case on cert grounds is that there is what's known as a circuit split. Now, what a circuit split is where you have some federal appellate courts in parts of the country ruling that a law is one thing, and then you have other courts in other parts of the country that rule almost the complete opposite about what that law means. And what happens in that situation is you have a situation where, people in part of the country are being subjected to the same law with a different interpretation than Americans in another part of the country. So the Supreme Court will often, in that event of a circuit split, where let's say the Second Circuit says X and the Ninth Circuit says not X, the U.S. Supreme Court will often get involved to resolve once and for all whether it's X or not X, and how to interpret that particular constitutional provision or that federal statute or whatnot. Now, that is usually when they get involved. My concern is in the context of assault weapon cases involving semi-automatic rifle bans or magazine bans that hold more than 10 rounds, is that you're never going to get to a circuit split. The reason why you're never going to get to a circuit split is because in the red states, you're never going to have laws enacted in the first instance that can in turn be challenged. So you have this one-sided bias, and I used to talk about this before Bruin because you would always see the anti-gunner, and the media would say that all the judges, or almost all the judges in America, have always ruled in favor of gun control. But they always conveniently ignore the fact that one of the reasons why that's the case is because the only places the gun control laws are getting enacted and thus challenged are in these blue states of New York, New Jersey, California, Illinois, Maryland, and so on. And the judges that are in those states tend to be handpicked by Democratic senators, and thus they have the political viewpoints of the Democratic senators that help pick them and put them on the federal bench. So in light of that, you have a skew where you have most of the cases involving gun control laws are upheld or are viewed or analyzed by blue state judges. So here, where you do not have quote-unquote assault weapon bans getting enacted in the red states, you're never going to have laws enacted, and as a consequence of that, they're never going to be challenged successfully in court because they're never going to come before a red state judge in Texas or California, or in Texas and Florida and the like, because as a practical matter, they're not going to have an opportunity to weigh in on things, and courts only get involved with cases that come before them. If there is no law to challenge on Second Amendment grounds, a judge in Texas is never going to have a chance to rule on the Second Amendment as a general matter. So the reason why this has always concerned me is that an argument I could see made against the Supreme Court having to hear a quote-unquote assault weapon case dealing with semi-automatic rifles or magazines holding more than 10 rounds is that there's no circuit split, and that would be a get-out-of-jail-free card for the anti-gun movement in America. Now, of course, my response to this is that there is another way that the U.S. Supreme Court gets involved, and that is if it's an important matter of public policy that affects a lot of people. And that is where we get into this United States versus Fischer case involving the interpretation of 18 U.S.C. 1512. The U.S. Supreme Court has just granted cert to hear this case. The reason why this is very good news for us is because there is no circuit split. There is no circuit split on what 18 U.S.C. 1512 means. The reason why there's no circuit split is because when it comes to the January 6th prosecutions, the Department of Justice has chosen to sue, or not sue, but charge everyone criminally in the District of Columbia, in a single jurisdiction, specifically so they don't have the risk of a circuit split, which is why a lot of these January 6 people are all basically being charged in the District of Columbia, even though they could be charged in other places like Florida and Arizona and so on, because a lot of the activities and actions that were allegedly wrong by that alleged by DOJ against these individuals occurred in states outside of D.C. when they were preparing to come to D.C. for January 6th events. Nevertheless, the D.C. Department of Justice has decided to home field themselves because that's what they do. So they're charging everyone in D.C. where they get the benefit of Democratic-laden D.C. juries and D.C. judges and deep state-connected people up and down the line, which is, if you're on the DOJ side today, that's exactly what I would do because it makes it a lot easier for them to win these cases and to leverage these things into very favorable plea bargains. But one of the games that's being played involves this 18 U.S.C. 1512, and I'll just spend a minute explaining what it means. Specifically, after the Enron financial fraud, where Enron was a major corporation that went belly up because it was a total fraud, there was a series of laws enacted called Sarbanes-Oxley, and one of those laws said that arose out of this is you could not destroy evidence or tamper with witnesses or do anything along those lines to hamper an investigation into financial fraud. Now, this statute was written a little bit more broadly, but it was all motivated by preventing corporate fraudsters from basically destroying evidence or tampering with witnesses when people go to investigate the companies as to whether or not there was a corporate or business fraud going on. That's where it came out of. And what's gone on here is that the Department of Justice has used a specific phrase from this law and said that anybody who obstructs, influences, or impedes any official proceeding in any corrupt way, meaning with a bad intent basically, they can be put in prison. And the reason why the Department of Justice loves this law so much is because it has a 20-year sentence. So a lot of these people involved with January 6th, really they're engaged in misdemeanor type activity in the traditional sense, but when you throw on this section 1512 felony charge with a potential of 20 years in prison and a fuzzy interpretation by the Department of Justice as to what impairment of an official proceeding means to do so corruptly, you really create tremendous leverage against these criminal defendants. Well, anyway, whether or not this has been properly interpreted, I think it clearly has not been by the Department of Justice, but the U.S. Supreme Court, even though there's been no circuit split here, has just agreed to hear this case. And I think they're going to absolutely slap down the Department of Justice. I think there's almost no chance the Department of Justice is going to be able to sustain these convictions under 18 U.S.C. 1512, at least as to how they are interpreting these laws, because they're clear, and I'm not going to bore you with the details here, beyond saying that this is a law that is specifically designed about destroying evidence and tampering with witnesses. It has nothing to do with, and also with financial benefit. You're doing it for the benefit of your wallet and pocketbook or somebody else's wallet and pocketbook. It has nothing to do with political protest under the First Amendment or allegedly under the First Amendment, where you want your preferred presidential candidate to sit in the White House. That has nothing to do, in my view, with what this section 1512 criminal statute that DOJ has been using as a hammer on these January 6th defendants. Nevertheless, we don't need to break it down beyond that. So all you need to know is this, that the U.S. Supreme Court just granted cert in this case, even though there's no circuit split, and they did so on the grounds that there were a lot of people involved that had been charged with 18 U.S.C. 1512C. There's real questions as to whether or not the Department of Justice is overcharging these cases, violating the First Amendment in these cases, because the way they charge these cases is they say that you were on the Capitol grounds on January 6th. Then they go back and look at the social media accounts, including arguably protected First Amendment communications, as a way to show that you corruptly intended to obstruct the counting of the electoral ballots in Congress on January 6th, and thus you go to prison for 20 years. And again, the fact that the U.S. Supreme Court has decided with its discretion to hear this case is telling, because I think if they're willing to hear this case involving these issues, then I suspect they'll be willing ultimately to hear a quote-unquote assault weapon case out of these blue states, even though, like in the Fischer case here, there is no circuit split. So again, I think this is a good sign for the ultimate challenge to these quote-unquote assault weapon bans by the Supreme Court, or in front of the Supreme Court. So this Fischer thing, which of course is quite an interesting case, but we're not going to talk about the details beyond what I just said. Again, I do think it's a sign that the Supreme Court is willing to step into controversies that affect lots of people, even in the absence of a circuit split, which again, I don't think we're ever going to have a circuit split on the quote-unquote assault weapon ban cases, because again, there'll never be a circuit that gets a chance in the red jurisdictions to be able to rule against the assault weapon bans, because those bans will never get enacted in the first place, and since they're never enacted, they will never be challenged in court, and no one can rule against them. Thus, you won't have a blue state versus red state circuit split on the question, because again, there is no circuit split of 18 U.S.C. 1512, because all the cases brought by the Department of Justice are in D.C., and as a consequence, they are specifically designing their strategy to avoid circuit splits, because they don't want some state like Florida or Arizona or Texas to rule differently on how DOJ is applying 1512 to these January 6 defendants. So anyway, a bit of good news. I know this is a little inside baseball. I talked about this on Maria Bartiromo this morning, at least about the statute and what it meant for Donald Trump. So I thought I would bring you up to speed on this a little bit, since a lot of you may not have gotten up that early to see me on with Maria. So anyway, there you have it. I hope you learned something here today at the Four Boxes Diner. Don't forget to subscribe and share with your friends, and don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.